When people talk to me knowing that I am an experienced family lawyer, probably the most common question they ask is, if I let my partner move in with me, will he or she get half my house? Or put another way, does living common law mean giving up half your house? Unfortunately, this is another one of those times when a lawyer is going to tell you, it depends. The Ontario Family Law Statutes are drafted so there was a quick, simple, straightforward answer. And then judges made it complicated. In this episode of the Ontario Family Law Podcast, I will explain whether living common law means giving your ex half your stuff. I'm John Schuman, a certified specialist in family law in Ontario with extensive experience assisting clients with high or complex incomes. I'm also a mediator, arbitrator, and collaborative lawyer. I have a best-selling book, The Guide to the Basics of Ontario Family Law. The new 5th edition has up-to-date information on all common family law issues. It is available on the iBook Store, Amazon, and in fine bookstores. So what does it mean when you let your partner move in with you? A common relationship is an intimate relationship where the partners share their residence, or according to a recent Court of Appeal decision, have a long-standing intimate relationship in which the partners have separate residences but stay together intermittently. Parents are considered to be living common law if they live together for any period of time and they are the natural or adopted parents of a child. For the purposes of getting money or benefits from others, partners are common law pretty much right away. For many purposes, parties can share a residence for only a short period of time to be considered common law. This is true for taxes, employment benefits, survivor pensions, and other things. Many partners get access to their partner's employment benefits as soon as they move in. The tax benefits come with the filing of the next tax return. But when it comes to getting money from each other under Ontario family law, living common law has a different definition. For common law spouses to claim spousal support from each other, they must be in an intimate relationship and have lived together continuously or intermittently for 3 years, or have lived together for any period of time and have a child together. Then they can claim spousal support and get family law restraining orders from each other. Now I can hear the followers of this podcast saying, but wait, that has nothing to do with owning each other's stuff. Well, spousal support claims can be worth a lot of money. And by that I mean one spouse owes the other a lot of what he or she has. Note the other episodes and my book cover spousal support in detail. These are not claims to actually own each other's stuff. That is because under Ontario family law, unlike the law in other Canadian provinces, common law couples have no legal right to each other's stuff, or even to make a property division claim just on the basis of being common law. Even the Supreme Court of Canada found that when couples chose to live common law, they are choosing not to live together as a married couple. So they are choosing to not share each other's wealth during the relationship, except as permitted by spousal support. They are choosing not to have the ability to make property claims solely on the basis that they live together. So, living with someone else does not give that person any right to your stuff. So that should make things easy. As I explained in episode 91, at the end of a common law relationship, the partner who owns the house can kick the other one out. Unfortunately, it is not that simple. Ontario Superior Courts are courts of equity in addition to being courts of law. There's a long history lesson here that you don't really need to know, but to summarize, a long time ago there were law courts in England and there were courts that made sure things were fair. The Ontario Superior Court is a descendant of both courts, so where Ontario law does not prohibit, Ontario Superior Courts can make an order based on fairness, called equitable remedies. This matters because at the end of a long common law relationship, particularly a long one, or particularly a relationship where one partner made a lot of sacrifices for the other partner, or for their particular assets, or for the whole family, it can be really unfair that the spouse leaves the relationship with nothing. A common law spouse who was treated unfairly can apply to the courts for a declaration that he or she was treated unfairly, and that his or her former spouse was unjustly enriched by the relationship. Then the court can order equitable remedies. Common law partners ask for these equitable remedies a lot in family court. These are the remedies where a common law partner can ask the court to declare him or her to be a part owner of a home to which the other partner has sole title, or even where the other partner has title with members of that partner's family. Most often, a partner wants to be a half owner of a particular asset, usually the family home. This is because he or she believes that the partners intended that the home belonged to both of them, regardless of what title said. And so the partner making the claim put a lot of money or his or her own work into the property. If this sounds complicated, it is. To make sure you understand how these equitable principles apply to your situation, you should speak to a lawyer and get a copy of my book, which explains them in even more detail starting on page 164. Also, remember, you can get a lot more useful family law information by subscribing to this channel, hitting the like button to get more information like this, and clicking on the notification bell, and you will find out as soon as my next episode comes out. To be successful in making such a claim, a common law partner has to show either that his or her partner who has title put it in writing that the house really belonged to both of them, and an email can be sufficient to do that, or that his or her partner will be unjustly enriched if that partner is allowed to keep sole title of the home. To prove that, the partner making the claims must show, first, the other partner has been enriched. The value of the house or other asset has gone up, or perhaps the mortgage has gone down. 2, the partner making the claim has lost out. They have put their money into the house, or they have put their own work into the house, or possibly into the family so that the other partner can make more money to put into the home. 3rd, there is no legal justification for the first partner to have been enriched. A legal justification could be that the other partner would otherwise have had to pay rent, so it is fair that he or she contributed something to the home instead of having to pay rent. Family courts are very willing to allow these claims to proceed and very reluctant to put a quick end to them. Judges have said that a person may have a claim to an ownership interest in the house because that person hung drapes, or put up wallpaper, or painted, or looked after the garden of a house that the owner inherited. Any contribution to the home can justify taking the issue to trial at enormous cost, which means the spouse who owns the home may have to make a large payment just to avoid the larger cost of trial. It is important to know that under equity, it is preferable that a partner be compensated by money, either spousal support or payment for damages, rather than getting to be an owner of the home. But making that payment can still sting. To know how that will work out best for you, make sure you meet with a good family lawyer. Get a copy of my book and check out the other episodes. Incidentally, the fact that a common law partner can pursue a claim to own part of the family home for doing very little is one of the big reasons for getting a cohabitation agreement before moving in together. That agreement can specify exactly what share of the property each partner will get after the cohabitation or the relationship ends. If you are finding family law or children's law confusing or difficult, or you just need to understand it better, or you need to know how best to make parenting work after separation, or you need to understand how finances work during a marriage or common law relationship and after separation, get the latest edition of my book, Guide to the Basics of Ontario Family Law. The latest edition is already on the bestseller list, just like all the earlier editions. You can access it immediately on the iBookstore, on Amazon for the Kindle version, or Amazon can also deliver the paperback version directly to your doorstep. You can also get a lot more Ontario Family Law information on www.schumanlaw.ca. Not only are there hundreds of pages of family law information and links, but there are links to get my book and links to reach my office to meet with either me or one of my colleagues. You can also contact us to make an appointment to speak to us using the contact information in the description. It is always best to get a lawyer who can give you expert advice that's specific to your situation. In addition to my website, keep up to date on family and children's law issues by liking my Facebook page, following me on Twitter or X and Mastodon at @SchumanFamilyLaw, and finding me on LinkedIn. I'm also on Threads. Of course, please subscribe to my YouTube channel and hit the notification bell to keep up to date. You can get the audio versions of the Ontario Family Law podcast on all major podcast services, including Apple Music, Spotify, Google Podcasts, Amazon Music, and many more. Or you can get all the episodes at www.schumanlaw.ca. Just look for podcasts in the drop-down menu. Thanks for participating in this podcast. We will get together again soon.